Ladies and gentlemen, welcome to the Humboldt County District Attorney's Runoff Candidates Debate on Civil Liberties, featuring both remaining candidates for DA of Humboldt County. Of the 58 counties in California, 56 of them have district attorneys standing for election this year. Of 18 contested races, Humboldt County is one of only 5 counties who face a DA's runoff election, a testimony to the vibrancy and political debate in Humboldt County, and a reflection of the community's concern for the issues of justice, safety, and civil liberties. The Redwood chapter of the American Civil Liberties Union is sponsoring this debate with the help of our state affiliate, the ACLU of Northern California, as part of their What a Difference a DA Makes campaign, which you can find more about at their website, www.aclunc.org/justice. The Redwood ACLU has over 850 members on the North Coast who are dedicated to preserving, protecting, and defending the fundamental rights and freedoms contained in our state and federal constitutions. And the public can find out more about us by visiting our website, redwoodaclu.blogspot.com, or by calling 707-442-4418. We thank all of you for joining us today, October 12th, and we also thank Charles Douglas, David Giarrizzo, and Michael DeKay of the Humboldt Sentinel for their work in bringing this debate to a live television audience on Channel 12. In fact, this is the first live production by independent producers out of the new Media Center studio here at Access Humboldt in Eureka, and we thank our local public access television system for their help as well. My name is Greg Allen, and I'm the chair of the Redwood chapter of the ACLU, and I'll be moderating tonight's debate with the help of our timekeeper and our question sorter, who will actually be taking audience questions via postcards. The format of the debate is as follows. We will have 2-minute opening statements by each candidate, the order of which will be determined by lot, as with the order of reply for all questions. The first phase of debate will center about 5 questions posed by the moderator concerning civil liberties issues in Humboldt County, with each candidate given 5 minutes to respond to each question. Candidates will also be given the opportunity to make 2-minute rebuttal statements, but no more than once per question. The second phase of the debate will center around questions posed by the live television audiences watching on Channel 10, Channel 12. Viewers, if you are watching the live program this evening, October 12th, please call 707-267-9120. That is 707-267-9120 to get your questions in. These questions will be taken by the question sorter. Only questions that are directed towards both candidates shall be forwarded to the moderator in order to avoid loaded questions and personal attacks. As with the first phase, each candidate is given 5 minutes to respond to each question. Candidates will also be given the opportunity to make a 2-minute rebuttal statements, but no more than once per question. Lastly, each candidate will be able to give closing statements up to 5 minutes. Again, members of the public can call 707-267-9120 with your questions starting now. All right, candidates, let's begin with your opening statements. And I believe that you are first, Ms. Jackson.
Thank you, Greg, and I'd like to thank the Redwood ACLU for hosting this event tonight. It is extremely important to the community. On November the 2nd, ladies and gentlemen, I'm asking you to join me in help making history. None before has there been a woman district attorney in Humboldt County. This race is a nonpartisan race, but I happen to be a Democrat, a lifelong Democrat, and a 4th-generation Democrat, raised with the values and principles of being essentially recognized as a party of justice and protecting the most vulnerable. I stand on a no-nonsense platform of effectiveness, of accountability according to proof, and a staunch commitment to honoring the rights of all, both the accused and victims within the criminal process. This no-nonsense approach has earned me the endorsement and the vote of confidence of a great cross-section of this community. Domestic violence experts and advocates, child abuse experts and advocates, victims advocates, and Republicans, Democrats, Libertarians, all sorts. It's also earned me the support of law enforcement up and down the North Coast, including the sheriffs from Humboldt, Del Norte, and Mendocino counties, as well as the law enforcement associations of the sheriffs, Arcata, Fortuna, Eureka, the deputy sheriffs, and the correctional officers. It's also earned me the vote of confidence and support of the largest union in Humboldt County, which is AFSCME 1684. I look forward to your questions tonight, and I ask that you join them in supporting me in making history on November the 2nd.
Mr. Gallegos.
Thank you. Good evening, Greg. I'd like to thank, of course, the Redwood ACLU for hosting this. I also want to say hello to my wife and children who are watching this tonight. My name is Paul Gallegos. I am your district attorney, and I have served this community for the past 8 years. Excuse me. Prior to serving this community as the district attorney, I received a Bachelor in Economics from the University of Southern California and a Juris Doctorate in Law from the University of Laverne. I have experience in state and federal courts at both the trial and appellate level. Throughout my careers, district attorney and private attorney before becoming district attorney, I have fought to ensure that the protections and the limitations of governmental power enshrined in the United States Constitution are respected and the law is applied equally to all. I have fought prior to becoming the district attorney and district attorney against individuals, strong, wealthy individuals and corporations, and to make sure that the laws protect each and everyone equally. I have continued to do that as the district attorney and have worked to prioritize violent crimes in this community and protections for the most vulnerable. From the elderly to children to dependent adults, I have worked to make our office more efficient, more effective, and more accessible to the community, to victims, to minorities, to all people in this community. And I ask you to support me on November 2nd and vote for me on November 2nd so that we continue the outstanding work we have done on behalf of this community in the past 8 years. Thank you.
Thank you, Mr. Gallegos.
Of course.
Appreciate it. Did you get a chance to finish? I'm going to cut you off.
Actually, time ran out.
Okay. So maybe for our first question, do you support reducing spending on corrections? And if so, how? If not, how do you propose to fund the current corrections system?
I'm not sure who you're asking first, Greg.
Who are you asking first, Greg?
Since Allison did our first statement, when we have Paul.
Okay. Certainly our prison system has become very, very expensive. Prisons and jails are not just mortars, bricks and mortars. What they are is it's an expensive infrastructure. It is the cost associated with correctional officers, psychiatric nurses, of course, all those people's salaries, benefits, retirement programs, food, medical care for the inmates. We, the United States, leads the world, I believe, in incarceration, and California certainly is a leader in incarcerating its citizens as well. The problem is that you have to approach it in a holistic manner. You can't get rid of one without providing alternatives to incarceration. What I have seen certainly over the past 8 years with the budget crisis is a reduction followed by a reduction, followed by a reduction of the alternatives, meaningful alternatives to incarceration, from drug and addiction treatment to domestic violence counseling to treatment on all sorts of levels. So, certainly we have an overexpensive prison system, but at this point, I cannot support reducing the cost of our prison system without the alternatives in place to keep the community protected. So, that is my responsibility to the community to promote public safety, and until there are those alternatives, prison and the expense associated with prison are what we're going to have to deal with.
Yeah, okay. Ms. Jackson, I guess you're trying to respond.
Yes, I believe your question was, do I support reducing spending in our prison system? But can you repeat that second portion?
Yes. I mean, do you support reducing the spending in corrections, and if so, how? If not, how do you propose to fund the current corrections system?
Well, do I support reducing spending? Not at this point. I do not given the state of California. I do not, however, believe it's the function of the district attorney's office to, in one county, to come up with how to fund the correctional system. That is historically done by our state legislature, and it's done through a long process of trying to determine what is in the best interest of all citizens in California. We'll say that the primary function of the district attorney is to really prosecute crimes within her jurisdiction or his jurisdiction. To do that, you have to be able to staff an office and put cases together sufficiently to where you can prove them, of course, in a criminal proceeding. Now, I agree that we need areas that we can rehabilitate certain segments of our society. When I say rehabilitate, I'm looking and thinking about areas on domestic violence, child abuse, and sexual assault. However, and of course, drug abuse. However, in order to get someone into a program of that nature, you have to have an office that is run to the extent where you can prove the cases in order to have that person then be placed on probation so that they will go into a program of domestic violence, regarding domestic violence, or they will get into a program regarding drug abuse, or they will get into a program regarding interfamilial violence of all sorts, including child abuse and sexual assault. So while I don't mean to hodgepodge and around the question, it is just really simply not for a district attorney's candidate to come up with the mechanisms to fund the criminal justice system. It is really a function of our legislature.
Okay, we need now for a rebuttal, Mr. Gallegos.
It really is no rebuttal. I missed the last part of your question regarding how would you fund it, but I have it now. It's all right.
Yeah, I mean, basically, how? I mean, would you support reducing the cost? If so, how? If not, how do you propose to fund it?
Well, what I would tell you is this. My assessment, by and large, is that what we do is we backload our investments in our community rather than front-loading the investment in an education system, in a meaningful, effective education system, and alternatives such as treatment to incarceration and counseling. We backload the expense, a very expensive way to deal with the problems of the prison system. So certainly the way to address the costs associated with the prison system is to redirect money towards effective, meaningful rehabilitation, effective, meaningful education, effective, meaningful treatment, including psychiatric counseling and drug and addiction issues. Drug and addiction issues are an overwhelming cause of criminality. And we simply need to understand that unless we address the underlying issues associated with criminality, we're going to continue to have both crime and the terrible expense associated with incarcerating people. Prison certainly is an effective way of making the community safer, but it is not an effective way of currently of rehabilitating offenders, nor is it a cost-effective way of addressing the underlying issues associated with crime. So there certainly are ways to address the over-expense associated with our prisons. Unfortunately, it does rely on our legislators to act accordingly.
Thank you, Mr. Gallegos.
Of course.
Ms. Jackson?
Yes, and I'll just be very brief here. I think it still dodges the ultimate question. I keep on hearing things like backloading an investment and front-loading an investment. The simple fact of the matter is, as people, our realities are constructed by different things, and it has to do with all sorts of things like our class, our race, our history, anything that makes us, goes to our identity. And one of the things that we do know about behavior is that you can't force a change of behavior on anyone. Each of you knows this, perhaps on January 1st, who makes a New Year's resolution that they do not keep. Trying to impose that type of change on another individual that doesn't wish to modify their behavior is often very, very difficult. It's not done voluntarily often, and that's where you need the criminal justice system to intervene in order to for lack of a better word, have a bit more control over that individual to try to force them to modify their behavior. And when I say modify their behavior, I mean with the intervention of the criminal justice system and the controls in place, you have sometimes the best way that you can modify that behavior when it comes to trying to get individuals off illegal substances or trying to get people to quit battering their partners or their spouses. And it is through a strong office that maintains a conviction rate that will allow these people to get into programs that will be able to modify their behavior.
Thank you, Ms. Jackson. Move on to our next question. Death penalty trials require many more resources from the prosecution, defense, and court systems than other homicide trials, and cost the taxpayers millions each year. Are you concerned about the amount of money and resources used in death penalty cases? What would your policies be as district attorney when deciding whether or not to seek the death penalty? Would you support changing the law to replace the death penalty with permanent imprisonment? So we do have compound questions here, but I mean, if anyone had missed any of them, just ask me. Ms. Jackson, you're up.
Well, I'm actually going to have to ask you for the last two parts.
You
I've got the death penalty trials. Are you concerned with it? And then you have, could you repeat the last two parts?
Sure. So I mean, so the first part is regarding the resources in death penalty cases.
Yes.
What would your policies be as district attorney regarding whether or not to seek the death penalty? And then the last, would you support changing the law to replace the death penalty with life imprisonment?
Well, you are absolutely correct. Death penalty trials are an enormous expense in any county. They bring with them dual counsel for the defense. They're extraordinarily long, and as I said, I agree with you, they use an incredible amount of resources. Yes, I am concerned regarding the use of the death penalty in any county, and I can tell you that the policy that I would have, because I inherently believe killing is wrong, will be, I understand that one must follow the law, and the law is set forth by the legislature. However, it's also determined by community standards, and it's these community standards that would dictate those decisions. I believe that any jurisdiction that ever considers the death penalty must always consider it as an absolute last resort. And I thank goodness I live in a county that has not had to even resort to even asking for a death penalty case since I believe the 1980s. It's been at least 25 years. And I would hope that we would not see the type of violence that would require anyone to make that decision. Do I support a change from the death penalty, from this state, from having the death penalty to one of life imprisonment? Yes, I do. I absolutely do. I believe in it both on a moral ground, and that is first of all and foremost, but also on a financial ground. These types of cases are so long, they are so involved, they are so emotionally draining on everyone within the system, including but not limited to a surviving family member who often waits for 20 and 30 years. It is just simply a time to rethink all of this.
Thank you, Ms. Jackson. Mr. Gallegos?
Thank you. Certainly regarding the costs associated with death penalty cases, they are tremendously expensive, as they should be. Before the state has the authority to take someone's life, we should do everything in our power to make sure that that person is in fact guilty, and that person has had all the protections of the United States Constitution. That's why from the moment a death penalty case is filed, immediately two attorneys have to be death penalty qualified, are appointed for the defendant, and if the defendant is convicted, there is an automatic appeal There are extensive appellate and writ of habeas corpus rights, and these are all appropriate, although very time-consuming and expensive, because it's important that if we're deciding to terminate someone's life, if the state is, that that person is in fact guilty. Despite all those protections, there are still repeated incidences of people that are subsequently found not guilty, and certainly that raises a concern. One of the other issues, a fantastic cost, although one that's not quantifiable, is the disparate application of the death penalty throughout our country, throughout our state. That is a tremendous cost, a social cost, because it weakens the integrity and the for lack of a better term, the majesty of our system of laws. When we find that the death penalty is disparately applied based on race. So there are both fantastic financial costs and fantastic social costs associated with the death penalty as it currently is applied. Having said that, because I am personally opposed to the death penalty, what I've put, and it is the law, I have put in place policies in my office where whenever we have cases where someone is, the circumstances are such that we could charge a death penalty case. It is thrown out between all the felony attorneys so that they can weigh in on the decision. And ultimately, of course, I would have the final say. But unless everyone agrees that the death penalty is appropriate, then we do not proceed on the death penalty. And we have not had a case where we have had such a consensus. We certainly have had cases where individuals thought the death penalty was appropriate. But it is a tremendous responsibility. And as a district attorney, despite your personal feelings, you have a tremendous responsibility to the people that you serve. And if the circumstances are such that justice cries out for another death, which frankly I hope we never have those circumstances, then my job, despite my personal feelings, is to seek the death penalty and the hope that the decision that ultimately is reached by the jury and the court is one that is accurate and is one that is appropriate, and so that I can live with that decision for the remainder of my life.
Thank you, Mr. Gallegos.
Thank you.
Ms. Jackson, you have 2 minutes for rebuttal.
No. I don't need any, Greg.
Okay. Mr. Gallegos, anything else?
I have nothing to rebut.
Wow. This is historic, folks. I mean, two attorneys taking less time to talk than they're allotted. Because you saw it here first.
I told you, Greg.
You did. What would your policy be regarding charging juveniles as adults in Superior Court? When would you use your authority to file charges in Superior Court as opposed to juvenile court? And when would you pursue a case in juvenile court? And I guess our first responder is Mr. Geiger.
Me. That decision is delineated by law, and the way it works is this: all juvenile cases that are not within the exceptions provided by law where they can be filed as adult cases are filed in juvenile court, all of them. Those cases that statutorily are eligible for filing in the adult court, there are two options. One is to file in the juvenile court and then petition to have it removed to the adult court, or to direct file, as we call it, where you file directly in the adult courts. We certainly have had circumstances where direct filing was appropriate, and we have sought that. There certainly is judicial review of that decision. Those cases have been particularly heinous. We had one case involving a young juvenile who, after shooting a cow out in the South Bay area, cutting off its ear, killed, at first robbed, and then tortured, and then killed a homeless man on the South Bay. And this homeless man had, with the last amount of money he had, it was his birthday, had bought a 6-pack of beer and had welcomed this young man to share it with him. And the young man felt that the remaining change should be his, so he shot this homeless person in order to make him give him his money, and then ultimately murdered him. So we did direct file. We felt it was appropriate. I continue to believe that was appropriate. It was a particularly heinous crime. And you know, I would tell you that that's my job. Having said that, I never take that job I never take that position lightly. There is a reason why juveniles are in juvenile court, and unless there are particularly egregious circumstances, we do not, nor would we, bring a juvenile into the adult court system.
Thank you, Mr. Gallegos.
Of course.
Ms. Jackson.
Well, I can tell you that with respect to juvenile crimes, this is one that I have a lot of history and experience with. My grandmother was appointed to the Board of the Youth Authority in 1960 by then Governor Pat Brown, and I was raised with these issues. All cases regarding juveniles should basically start out in juvenile court unless, and there's a big unless here, unless they're a violent felony, and there are delineated which cases can be filed in adult court when you have a juvenile. There's a minimum age frame with respect to filing those types of cases in adult courts, but they should, as I said, be left by statute to those crimes involving violent felonies. Whenever you're charging a juvenile, whether they be in juvenile court or in adult court, you always look at several issues, and that is the context of the crime and the severity of the crime. Mind you, one of the reasons why the only serious felonies, or excuse me, only violent felonies are really looked at as being an avenue to place juveniles in the adult system is because the juvenile system is not about retribution. It is not about simply punishment. The juvenile system is about rehabilitation and trying to get these children to conform their behavior so that they do not enter the adult system. To me, there is no child that should ever be thrown away. And if charging decisions aren't made appropriately with respect to these juveniles, they may get stuck in a system in which they don't get out. We do know that the numbers of adults who have been in correctional or currently in correctional facilities that have gone through the juvenile justice system is unbelievably high. So it would be my intent to only file those violent felonies in adult court when the context and severity and the particularities of the youthful offender are such that they warrant that adult treatment. Because as I said, the primary function of the juvenile system and how we should be treating juveniles is to rehabilitate them in every way that we can. And it is only as a last resort. It is only when we have young people, 16, 17, and 18, that have actually 17 and 18 that have committed very violent offenses, should they be treated as adults in the adult system.
Thank you, Ms. Jackson.
You're welcome.
No, sorry, did you have enough? I'm sorry.
Yes.
Mr. Gallegos, you have 2 minutes for rebuttal.
I don't think there's anything to rebut in that.
Fair enough. Ms. Jackson?
Can't rebut myself.
Good point. Move on to our next question. Sobriety checkpoints are in more and more frequent use by local law enforcement agencies. Even though, in one recent example, Eureka Police Department caught more drunk drivers by conducting routine traffic patrols than by running a checkpoint. These checkpoints also tend to produce more vehicle impounds, more documentation issues as opposed to actually catching intoxicated drivers. Are you concerned about the police state atmosphere that's generated by essentially a papers, please sort of inspection point? Do you believe these checkpoints entrap drivers? And our first responder would be Ms. Jackson.
Thank you, Greg. Just taking a couple of notes down because that was an awful long question again.
I mean, they would never be allowed in too many compound questions. They'd never be allowed in trial, but we'll see if we can break these guys down. So the things
I've got it though. I do have it, Greg. I did write enough down, honestly.
Okay, go ahead then.
As to the sobriety checkpoints, yes, I do understand they're used a lot, but what most people don't understand is that they're not used solely to arrest drunk drivers. What they are is a deterrent to send a message out to the community. And that message is that there will be people out at certain points. It is the deterrent value that I believe is really the strong point with these types of checkpoints. Am I concerned that the checkpoints don't yield a lot of DUIs? No, I'm not, because as I said before, they are used not simply to detect people driving under the influence, but for other reasons, for deterrence. And am I also concerned that these are used as a can you repeat that latter part about them being used for entrapment?
Well, yeah, I mean, do you feel that they are used basically to entrap motorists? I mean, what we're talking about here is that often there are arrests or seizures made that have nothing to do with being intoxicated, but perhaps not having a vehicle registered.
Okay, I understand that, Greg, okay. And I just wanted to get to the end part of that question. And actually, no, I'm not. Driving is a privilege in the state of California, and we should have our registrations up to date, and we should have our insurance, and we should all be complying with the law. And often people are caught on a daily basis not complying, whether they be sitting at a stoplight or a stop sign. So no, I am not particularly concerned, because I don't see that as being entrapment. And trapping somebody is essentially, and that's pretty much a term of art, and that's having someone do something or suggesting that someone do something that they wouldn't normally do. It's the suggestion to them. Here it is just simply the detection of normally a lot of things like tickets. And I quite frankly feel a lot more safe if people are driving around with, as I said, with the proper insurance and the proper licensing.
Thank you, Ms. Jackson.
You're welcome.
Mr. Gallegos?
I absolutely support the sobriety checkpoints. I agree with Ms. Jackson. They have twofold purpose. One certainly is to identify people that are driving under the influence and to arrest them. The other part is to prevent driving under the influence. Driving is not a right, it is a privilege. And with that privilege of driving comes the responsibility of driving safely and responsibly. And frankly, under no circumstances can you be driving under the influence of alcohol and be driving responsibly or safely. So, and I want to emphasize that we have a society that allows drinking, and that's perfectly fine. And we have a society that allows driving, and that's perfectly fine. What our society says is you don't get to do both. If you're going to drink, fair enough, you may have a certain amount, but you may not drink to the point where you endanger others. That is your responsibility. Those are the responsibilities that are concomitant with the privileges and the rights that we have as citizens. Nothing more and nothing less. We have something in the neighborhood, somewhere in the neighborhood of 89,000 deaths in the United States due to drunk driving. And these are people, many of these people that are victimized have nothing to do with this conduct. They have not consented to it. They are not engaged in high-risk behavior. They are going about their lives, going home, going to the various activities associated with life. These are women, children, families. It is completely irresponsible, completely dangerous behavior, and everyone that's driving has a responsibility to drive sober and safely. So I do absolutely unequivocally support sobriety checkpoints. I do not see them under any circumstance as entrapment. Ms. Jackson is correct. We have a discrete definition in the law for entrapment. But even in the generic common usage of entrapment, it is not. These are not people that, but for the law enforcement officer, would not be engaged in criminal activity. They're engaged in criminal activity. Because they are stopped, the officer happens to find it. So I do not see it as entrapment under any definition, either common usage or under the law. And we simply need to do everything we can under the law to assure that our streets are safe. And people need to understand when they get behind the driving wheel and they're under the influence, it's not just them. They are, in effect, propelling a 1,000+ pound vehicle across our streets that when it hits bicyclists, those people don't live. When it hits other cars, many of those people don't live. You know, they need to understand. Drink if you must, drink if you will, but do not get behind a wheel.
Thank you, Mr. Gallegos.
Thank you.
Ms. Jackson?
Yes. If you have ever lost a friend or a family member, or ever had them seriously hurt by a drunk driver, you understand that the importance of making sure that we detect everyone on the road who is impaired, and that is impaired by any substance, whether it be alcohol or even a prescription or non-prescription narcotic. These types of crimes have destroyed families and will continue to. And as I said before earlier, I do not see this as entrapment whatsoever.
Thank you. Mr. Gallegos?
Well, I would just agree with Ms. Jackson. I have heard and read of her own experiences. You know, drunk driving has touched most people in this country. I had a brother years ago, drunk driver, crossed the median strip and involved him in a head-on collision. And he broke, his neck was broken, his hips were broken. These are tremendous consequences, societal costs, individual costs, and all the people of the state of California, all the legislators, all the prosecutors are asking people to do. We're not saying don't drink. We're not even saying don't drink and drive. Although I would say that one probably shouldn't do that. We're saying if you're going to drink and drive, do so responsibly and safely, and do not do so in a way that endangers the lives of others. So it's a terrible tragedy right every day in this country, and we have much more to do, not much less.
Thank you, Mr. Gallegos.
Thank you.
Now to our next question. Humboldt County voters in recent elections have been handed ballot initiatives with severe due process and/or constitutional conflicts that have led either to their defeat or the invalidation of these ballot measures. Do you feel the DA's office can or should play a more constructive role in assessing these draft ordinances prior to their submission to the voters? Would you agree to voluntarily work with ballot measure proponents and/or the county council to undertake such an analysis? And Mr. Gallegos?
No, I do not believe the district attorney should be involved in that. Certainly, if the district attorney is asked, and I certainly always work to assist, but really it is not the role of the district attorney. You have very many other appropriate vehicles for that sort of assessment, and you know, from county council, city attorneys, there are attorneys, private attorneys in this community that can certainly assist. The district attorney's role is an executive officer assigned with enforcing the laws of the state of California. It is the judiciary that interprets laws and the legislature that makes laws. And I think that those separation of powers, it is essential that we maintain them. And I think that it is fair for us to be asked our opinions, and it's fair for us to give our opinions. But to make that the role and the duty of the district attorney, I think, is a violation of the separation of powers.
Thank you, Mr. Gallegos. Ms. Jackson?
Yes, Greg, I do recall the last several years hearing of several initiatives or ballot measures that have come up within the county and within some of our individual communities that when I looked at, I saw on the face of them, I believed violated really significantly strong constitutional precepts. And I tried to be vocal about that, but that was on a private level. Can the district attorney's office play a constitutional role in doing this? No, I do not believe it can. The role of the district attorney or the role of the prosecutor is really defined in our government code, and it vests the district attorney with the authority and the jurisdiction to prosecute crimes within his or her community or jurisdiction. Therefore, there really isn't any constitutional authority to allow for that type of input. You've also asked whether or not, as a district attorney, if elected, I would be willing to meet with proponents of individuals, proponents of individual measures to help them draft it. Again, I believe that that would be a conflict of interest to, given the constitutional or the authority vested with the district attorney. As a private citizen, I wouldn't mind commenting to a few friends on what I thought would be the legality of it, but it would only be in a private arena and not in a formal arena, as I see those as being as conflicts. Would I meet with county council to discuss perhaps problems with them? Perhaps on a personal level I would, but again, it's the county council's jurisdiction to weigh in on those types of measures if they're submitted by the county, and it's not their jurisdiction, however, if it's submitted by individuals through the petition process. So no, I would count on individuals like you, Greg, and the other members of the ACLU. And if you commented one way or the other on the legality or constitutionality of any particular measure on our county or city ballots, and I would do what I could to express my support for your position. But as an official support of the district attorney's office, I think it really is out of the purview and really isn't that permissible.
Thank you, Ms. Jackson.
You're welcome.
Mr. Gallegos?
Oh, I would just only say that the district attorney's role as defined by law is much more expansive than simply prosecuting crimes. The district attorney's office, after the passage of Proposition 64, has almost exclusive jurisdiction over all unfair competition law enforcement. Those are referred to as Business and Professions Code 17200 cases. Many of our environmental enforcement and many of our, certainly the case involving the skilled nursing facilities, that was a 17200 case. Unfair competition law. Some of the lawsuits we've had against many of our larger corporations have been 17200 cases. The case against Target is a 17200 case. The case against Big Oil was. This is an amazingly powerful tool for compliance that's in the hands of district attorneys throughout the state of California. And it is simply inaccurate to say that our only role is the prosecution of criminal cases, because that is not the truth.
I do have a rebuttal.
You're good? Okay.
Yes. First of all, the role of the district attorney is actually defined in the government code as prosecuting crimes. But with respect to the 17200 cases or the unfair business practice cases, yes, that has been expanded to include that. However, I would point out when you have a situation when you have a district attorney who delegates that principal authority to private counsel, you're significantly risking the very law upon which 17200 vested the authority in the district attorney's office, which is what I believe happened in the skilled healthcare case. I believe that the deference to private counsel as opposed to the district attorney taking lead counsel to that with respect to the 17200 is really very much risking that entire section of the Business and Professions Code and the authority of other district attorneys in other counties to continue to prosecute under that section.
Thank you, Ms. Jackson. Well, this is the end of the easy questions, and now we've got some questions that have been phoned in from our live audience. These are the tough ones.
I look forward to it, Greg.
I'm sure everyone does. Where do the candidates stand on animal abuse? Ms. Jackson?
Well, I've got a long history of where I stand on animal abuse. I have been, when I was a prosecutor, I fought to to charge animal abuse cases, and I was successful in convincing my boss that they not only needed to be charged, but they needed and prosecuted, but they needed to be charged, some of them as felonies and prosecuted. I am an avid animal rights worker. I have worked in animal rescue for quite a few years. I am supported by so very many animal rights workers and rescuers in this county. And I can assure you that if elected as your district attorney, you're going to see an increase in how that office now will respond to animal abuse cases. I'm sure you remember the Mad River Dog case that came out of Trinity County. I believe that that case should have been prosecuted in this county. I had the opportunity to review the reports after those some odd 80 plus animals were found. Essentially, they'd cannibalized each other, locked into cages in Trinity County. And when I went through the report, it indicated that this was a crime that actually started in Humboldt County, was detected by animal control officers. And however, the case was rejected by the district attorney's office. There were clear signs of negligence, and I believe it should have been prosecuted. And had it been prosecuted, I don't believe that the individual would have been able to then flee the county with all of her animals, and I don't believe it would have ended up in the horrible mess that it did. I'm also very interested in cases, well, there's another case that came out not too long ago involving just a great deal of horses that were maltreated. And although I can't remember the precise number, I believe it was in excess of 30, that the individual charged with that abuse was actually plea bargained down to one misdemeanor count, if I recall the facts, and then restitution wasn't even ordered for the rescue groups that stepped in to feed and shelter these animals during the process of trying to hold the perpetrator or get to justice. I intend, if elected as your district attorney, to completely change that, and we are going to focus again on making sure that cases involving the either intentional maltreatment of animals or the negligent maltreatment of animals are given their proper prioritization. These are, animals are sentient beings. They feel, they hurt, they can be starved, they can be beaten, and they simply have to be treated as more than just simple property, which they've been referred to by our current district attorney. They are more than just simply property.
Mr. Gallegos?
Yes, thank you. Animal abuse, ladies and gentlemen, is broad spectrum. There is multiple levels of it. The most common form of animal abuse that we see is generally defined as neglect. The most common form of that sort of neglect is what's generally referred to as animal hoarding. And what we find is that certainly well-intentioned people, or often well-intentioned people, collect animals and attempt to provide for them. They love animals, and they either lack the mental or the physical capacity or the financial capacity to care for those animals. And certainly under those circumstances, what we do is work to put those animals in a safe place and make sure that an appropriate consequence is in place. Often that is counseling. Often that's prohibiting them from having animals in the future. There are another level, of course, of violence and cruelty to animals, and that is not only illegal, it's immoral. So, what I can tell people is not only do I have animals, I've grown up with animals my whole life. The law defines animals as property, not me. Anyone that owns an animal, has pets, they think of them as a member of their family. But we absolutely are committed to the prosecution of people that abuse animals, be it from the neglect and the hoarding to the violent activity. And I think my record establishes that. At the same time, we are always limited by the facts, and our job is to do what's right under the facts that we have and the law that is applied to that particular case. And sometimes that is reducing charges if the facts warrant it. You also have many legal issues for doing that, but that's simply the way it is. And we're absolutely committed to protecting animals as we are absolutely protected to committing human beings. And we cannot, in our fervor to protect animals, deprive individual human beings of their rights or their protections either.
Thank you, Mr. Gallegos.
Thank you.
Ms. Jackson?
Yes, I would like to add that most people may not know, some of you do, that I was a prosecutor for 10 years, over 10 years in the Humboldt County District Attorney's Office, and I specialized in crimes involving our most vulnerable children that were victims of or survivors of physical abuse or neglect or sexual assault, as well as the elderly survivors of domestic violence, as well as animal abuse cases. And I will tell you unequivocally, the reason why animal abuse cases have to be brought back in and looked at very seriously and prosecuted significantly is that we find that with respect to intrafamilial violence and actually violence in general, you'll see people that start out abusing animals then go on to abusing other vulnerable beings. And so if you see instances of intentional violence and this type of neglect towards animals, it's a good precursor for what this person or individual is going to do in the future, which is why you do have to take these cases extraordinarily seriously.
Thank you, Ms. Jackson. Mr. Gallegos? The only thing I would add is that absolutely, I agree with many of those studies. I'm very much aware of them. But the law simply does not allow you to punish someone for something they may do in the future. That is not allowed in the law. It is unethical and it's immoral. So I understand what she's saying. I certainly appreciate the sentiment. I certainly know the studies that support her position. But the law doesn't allow you to punish people for something they haven't yet done.
Greg, I need to respond to that.
I'm sorry, we can only have one
Certainly.
response per question, and everybody's had one. I'm sorry, Ms. Jackson. But in your closing remarks, I mean, maybe you might want to address that.
I will.
Okay. I want to go to another issue, and of course, this comes up in this district attorney's race, and any district attorney's race, any place, and that is the subject of plea bargains. Commentators have certainly stated that in California, between 90 and 95% of all criminal cases are resolved by a plea bargain. So my questions for you are, one, what is a plea bargain? And two, what is the economic relationship between plea bargains, the budget of the district attorney's office, and the cost of administering justice in the court system in Humboldt County? And so I'm trying to remember who our first responder is. I think this is Mr. Gallegos. Is that right? I think it is.
The definition of a plea bargain. What I would tell you is this. Certainly, probably 90 to 95% of all cases in Humboldt County, just as in other counties and throughout the state and throughout the United States, of all criminal cases resolve with a plea of guilty. And that's not someone being found guilty by a jury or a judge. So the paradox that many people don't understand is that the better the case, the more likely someone is going to plead guilty. So that statistic is a sign of success. Jury trials are expensive, they're uncertain, and they have tremendous cost on our society. We can only convict someone with a jury trial. That's 12 jurors coming out of the community, not going to work, not going about their lives, that are coming in to make a decision as to the guilt or not guilty status of a defendant. Having said that, certainly in our process, we don't, what we do is we focus on the cases, not the budget. So while we have an obligation to the community, since we operate on their money, to act efficiently and effectively and to not waste their money, We don't say, well, we only get to try this many cases. At the same time, the reality is this: we file in the neighborhood of 10,000 cases in Humboldt County per year. We have 5 criminal courts. Trials are done in a half-day status, so even a misdemeanor often takes a week to 2 weeks to try. And if we were capable of trying cases in a week, which we're not, 5 in that week, we would only be capable of trying somewhere in the neighborhood of 250 cases per year. All those other cases that weren't tried without what is often referred to as plea bargains would result in dismissals. So it is an essential and inescapable reality associated with our criminal justice system. I think I should probably stop at that and respond to any other questions. But the goal, if you will, that is sought to be achieved is resolving cases expeditiously and appropriately. And that means based on the facts, the law, and the equity associated with a particular defendant, that you reach the appropriate resolution. And we certainly strive to do that under all circumstances.
Thank you, Mr. Gallegos. Ms. Jackson?
Thank you very much, Greg. The Department of Justice reported in their 2003 to 2008 crime report that in just the year of 2008 alone, 1,460 felonies were filed in Humboldt County. They're the entity that's responsible for tracking those throughout the state. I agree with your proposition that 90 to 95% of the cases that come into the criminal justice system are plea bargained. Well, a plea bargain is essentially a negotiated disposition with respect to any one charge. Now, as far as economic relations between plea bargaining, finances within the district attorney's office, and justice, there are several things that are interplaying here that the public really needs to be brought in more on. With respect to overall plea bargains, no matter what kind of negotiated disposition is ever entered into, the punishment must always fit the crime. When it does not, justice is not served. However, when you're looking at and that regards any plea bargain, whether it be a misdemeanor or a regular felony charge. However, what you also must understand is that the laws defining what are appropriate and inappropriate plea bargains have really been set in effect for about 28 years. On, I believe it was June 6th, 1982, the people of the state of California, by way of proposition, passed a Prop 8 called the Victims' Bill of Rights. It amended Article 1, Section 28D of the California Constitution, and it provided, excuse me, for the first time in California's history, rights to victims or their surviving family members when they were in the criminal process. Before, they had no rights. All they had was the kindness of any one district attorney's office in affording them simple human dignity. In 1982, the voters said, we're going to make this a law and make sure that every district attorney in every county knows what the directives are. So with respect to Article 1, Section 28D, it did provide rights for the first time to victims and their families, but it also limited the ability to plea bargain in serious felony cases. And serious felonies are defined by a certain section of the Penal Code. That section is 1192.7, but it lists out approximately 42 or so crimes that the people of this state believed were so very important and significant that they wished to limit the discretion a district attorney normally has with respect to getting a negotiated disposition, and limited that to only when you have charged a serious felony and it has made it through a preliminary hearing and the defendant's been held to answer because there's been a probable cause hearing, then the law states that you cannot plea bargain a case unless one of three things happen. First, either you've lost evidence, second, you lost a material witness, or third, the negotiated disposition that you entered into is not substantially disproportionate with that which was already charged. Unfortunately, for many, many years, and still to date, there is no enforcement mechanism when you have a district attorney making decisions that don't comply with what the voters passed in 1982. You have one way and one way only, and that is through your ballot box. That is one of the reasons why I am running for a district attorney, because I believe that, like many, many, many others in this community believe, that you need a district attorney who will finally shut down the revolving door of plea bargains that is allowing violent offenders out on our street to offend again and again. That is what has been stated by law enforcement generally across the board. It's been what has been stated by victims and their families, and it's what has been stated by advocacy workers that work with victims in the field. So I feel very strongly about the fact that plea bargains must always be proportionate, and they must always comply with the law.
Thank you, Ms. Jackson. Mr. Gallegos? Would you respond?
Ladies and gentlemen, this is the way all felony plea bargains work, or felony guilty pleas work. A disposition is reached, a proposed disposition. Then that is provided to the court who is aware of the facts of the case and the charges. It is then referred to the probation department, which is an agency of the court, not the district attorney's office. That probation officer reviews all the police reports, then summarizes them along with the defendant's criminal record, summarizes the proposed plea agreement, and then makes a recommendation to the court. The court, at every step in the way, has complete, lawful, and unfettered discretion to reject the plea bargain. The court cannot accept an unlawful plea, and the court would not. So the court receives this probation report, reads it. The court, who also, individuals in our county, are very competent and ethical judges, know their responsibility to this community, and they will only impose a sentence if they believe it is appropriate based on the facts, the law, and the equity that they know to be associated with that particular case. The court cannot impose an unlawful sentence. Not only can the court not do it, if the court does, that can be kicked back through the appellate court process. These are procedures we have in place to make sure that everyone complies with the law. And to imply, suggest, or state otherwise is just complete misrepresentation, because we do have checks in place, and that is the court system.
Thank you, Mr. Gallegos.
Thank you.
Yes,
Jackson?
I think the district attorney is making a complete misrepresentation as to how the system works. The district attorney has the sole discretion as to what to charge. The district attorney has the discretion as to what counts or charges he or she will dismiss. The judge's powers are limited to imposing a sentence to the charges that there have been either have been proved at a jury trial or has been negotiated by the district attorney's office. So if you have a murder charge and it is then dismissed and it's substituted with a voluntary manslaughter charge, then that is all that a court can sentence on, is the voluntary manslaughter charge. And I do have examples where in one court, I believe it was one judge did not want a certain charge dismissed, where an amended complaint was then filed without that charge in there, thereby basically tying the judge's hands. And the district attorney was able to get the plea that he wanted for the reduced charge. So I will not allow Mr. Gallegos to misrepresent that the judge has the discretion over what cases, what charges he files and what charges he dismisses, because that is our separation of powers, and as the district attorney, that district attorney has that sole authority.
Thank you, Ms. Jackson. And I'm trying to remember, did Mr. Gallegos get a chance to respond? I'm trying to remember what our original order was on this. Did you get a chance to respond to this, Mr. Gallegos?
I'm fine.
Okay, thanks. Appreciate your candor. Okay, this is a question that's a little bit. I mean, it would apply to you folks as individuals, as district attorney or the district attorney's office, and that is, if you find out that you have a witness who's lying, and I mean one of the people's witnesses, you find a people's witness is lying, then would you still go to trial and/or insist that the defendant, plead out? And we'll go, I guess, Ms. Jackson.
Well, this is going to be a very short answer because it is just so upfront and in your face. If you find if as a prosecutor you are vested with the authority to do justice, and you are bound by ethical responsibilities that are even greater in some respects as are applied to other attorneys, and you're vested with that responsibility for a reason, because you exercise discretionary power over another individual. If, as a prosecutor, I found out that one of my witnesses were lying, would I go to trial? No, I would not put that person on. If that person was tangential and not necessary to the case, I would probably proceed with trial, but I would bring that information immediately to the knowledge of the defense attorney and to the court. Would I plead a case out in order to avoid doing that, putting a person who lied on the stand? Absolutely not. If that person was so essential to proving the case, then that case cannot go forward. That would be reasonable doubt unto itself, and this system isn't set up just to convict people. This system is set up to attain justice, and unless the prosecutor can prove beyond a reasonable doubt that someone is guilty, then you cannot charge a person and you cannot go forward. It's not enough to believe someone's guilty. It's not enough to think someone's guilty, but you must be able to prove it beyond a reasonable doubt. And at any time, and there's a bar rule that actually is on point, at any time, if there is a problem and you no longer are able to prove a case beyond a reasonable doubt, then it is an ethical responsibility for a prosecutor to dismiss the case, and it would be an ethical violation for that prosecutor to try to extort a plea bargain in the face of that type of evidence.
Thank you, Ms. Jackson. Mr. Gallegos?
Many of the things Ms. Jackson says I agree with wholeheartedly. At the same time, it really depends on the nature of the lie, and it depends on who is committing the lie. An example we deal with often is domestic violence. A report is made, law enforcement responds, the victim, or we think of as the victim, the woman more often than not, claims she was injured. She has injuries. There is both direct and circumstantial evidence that establishes, in our mind, that there is overwhelming evidence of guilt of the defendant. We charge the defendant. At a later time, that victim changes her testimony or her statement. And certainly that happens. We understand that. The question is, which story do we believe? Do we believe the story that she told the law enforcement officer that's corroborated by physical evidence? Or we believe the story now that we understand is a common response of victims to domestic violence? Our answer, depending on the circumstance of the case, is often we believe the victim's initial story. Certainly we believe the victim's initial story when there is circumstantial evidence that establishes that. A case that comes to mind is the case against Chief of Police Gunderson. Here we had a victim that came in, was recorded, talked about non-consensual sex. There were photographs to corroborate that. There was significant other evidence. At a later time, her testimony was different. And our position was we felt that her later story was dishonest. And under those circumstances, and I want to explain that it was dishonest because that was her safety plan, as it often is with victims of domestic violence. But our position is we believe the initial story and we are still going to go forward. Now, under those circumstances, there are oftentimes, because of our concern that we may not be able to get a conviction, we do agree to a plea bargain that we otherwise may not have liked. But it's not because we don't believe the person is guilty and we don't believe we can't prove them guilty. It's just there are additional risk associated with that trial that wouldn't be there but for the change, would not be there with the exception of that changed testimony of the victim. We have cases like that, rape victims. We have cases like that with child abuse victims, elder abuse victims. And what you have to do is look at the big picture. You have an absolute duty to work to achieve justice. But sometimes the lies, if you will, are not such that they indicate that the person is not guilty, nor do they indicate that you should not go forward or seek to get a consequence on that defendant. So that's the long answer to that relatively short question.
Thank you, Mr. Gallegos. Ms. Jackson,
You're welcome.
Respond?
Yes, I do. A recanting survivor of intrafamilial violence is significantly different than finding out that someone is lying. If you have someone who is lying about charges against an individual, you are absolutely duty-bound not to go forward with that lie. And as I said, there's a stark and contrasting difference between somebody intentionally lying and a recanting survivor of intrafamilial violence.
Thank you, Ms. Jackson. Mr. Gallegos?
I agree. In fact, if you have someone that makes a false report, that's a new crime and they should probably be prosecuted, and they would be.
Thank you, Mr. Gallegos. Let's may move for our next question. Tribals and communities are a major part of Humboldt County. How will you, as district attorney, work with our local tribes? Mr. Gallegos?
We work with our local tribes on a regular basis in a multitude of ways. First and foremost, certainly people need to understand that we have 8 tribal communities here in Humboldt County. We have the largest Native American population per county in Humboldt County. And they have suffered severe injustices at our hands. They have historical experiences that are carried into the present that affect their relationship with us, their trust in the system, and our ability to do our job of making their community safer. We have worked hard to address those past injustices. One of the things we have done is we created the DA Tribal Roundtable, a program that has received both state and national attention for its working relationship that we have. It is my office, the Attorney General's office, and all the tribes here. We meet on a monthly basis to discuss cases, address particular issues, and work on plans for issues that affect those communities. That can include things as working to get grants together, which we often do, to putting victim witness advocates, out into the tribal communities. One of the things we did years ago was work with the tribes to develop their own victim witness advocates, their SART, a sexual assault response team, and work with them to develop their court system, which we continue to do. Today, we had 2 meetings involving tribal issues and tribal communities. One is the Tribal Roundtable that now is in place with the Department of Public Health, and the other, of course, is with CAS. So there's a lot of work to do. There is a lot of work that we have done. I am proud of the support I've received from the tribes and tribal communities past 8 years and currently. These are members of our community, and they are entitled to the protections of our law, and we are absolutely committed to doing all that we can to reach out to them and certainly make amends for the past, but also develop a relationship for the future.
Thank you, Mr. Gallegos. Ms. Jackson.
Thank you very much, Greg. I can tell you that I've lived in this county since probably 1994, I used to come up to this county for many, many years, doing a lot of fishing, so I spent a great deal of time up around the Hoopa tribe and Yurok tribes. I can tell you that as a young prosecutor, I would, whenever I would have a case up, it concerned any of the tribal members, whether generally when they were survivors of crime or victims of crime, I would make sure that I contacted the community, contacted members of the individual tribe, or contacted tribal police, depending on the intricacies of each individual case. As a prosecutor, I would also meet with healthcare providers and other advocates within tribal communities to educate them into my particular field or specialty, which was crimes involving sexual assault and child abuse. For many of your viewers who don't know that I specialized in those crimes for about 10 years and was a past chairperson of the SART board, but it was not uncommon for me to go up and then try to educate different healthcare providers that served to help other tribal members as to how to identify certain crimes and how that they could better serve their community. I have spoken with numerous tribes during this campaign about how I could help them if I was elected to be your next district attorney. And through the tribes that I've spoken with, I've heard predominantly the response was, just listen to us and take action. Yes, we have a roundtable right now, and there are meetings that we have approximately once a month, but we express the same concerns, and time again, nothing is done. I can assure you, if elected as your next district attorney, you will have action and not words. I've got many, many, many ideas on how to bring more justice to our tribal communities, and for especially in those areas that there is concurrent jurisdiction under Public Law 280. I would like to start to see an expansion of the tribal council and the tribal courts dealing with issues involving substance abuse. And I think that that is an area that is much better, could be much better handled within a tribal setting, and much more successfully handled within the tribal setting for tribal members. I have ideas how to expand this out in other areas, but would like to see if first those ideas with substance abuse and addressing that on a tribal level are successful.
Thank you, Ms. Jackson. Mr. Gallegos, would you care to respond?
We have worked with the tribes. You know, Ms. Jackson's claims are completely false. We have worked with the tribes. The tribal roundtable is something that the tribes are very happy with. They're very proud of. We work with them on a regular basis. We have facilitated their receiving grants. One of the fundamental problems in the tribal communities is not a lack of the district attorney's office, but a lack of law enforcement. You have the Karuk people who have very little, if any, law enforcement presence. You have Hoopa with a diminished police force. We certainly provide, are always willing to provide training. We go up to the council, we go up to that community on a regular basis. We provide support services to them, and you know, we are there for that community. We have an understaffed sheriff's department because of budget cuts. We have remote areas, not only tribal communities, but remote areas that just receive, in their opinion, inadequate law enforcement presence. But it's not the district attorney's office that is not present in there working with those communities, far from it. We go there, we prosecute cases, we are there on a regular basis in their schools, at their tribal gatherings. We work hand in hand with all tribal governments, and we are absolutely committed to doing that on the basis of partnerships and collaboration and equality, as opposed to someone coming there and telling them how best to run their communities.
Thank you, Mr. Gallegos. Ms. Jackson?
Well, Mr. Gallegos and I will just have to agree to disagree on this one.
All righty. I want to remind our audience at home that if you'd like to, this is October 12th, if you'd like to call in and have your question answered by one of our candidates, please call 707-267-9120. That's 707-267-9120. Well, how can the district attorney make the community safer? Ms. Jackson?
Well, the first thing a district attorney can do is run an office to the extent that you staff it properly and have the correct supervision and training to charge cases appropriately and to have those cases then prepared adequately so that they can be proven at trial so that they somewhat can avoid the full-scale trial, that a district attorney can make the public safer by making sure that those who have committed crimes against other individuals within the community are held accountable according to proof while their rights are being upheld. And you essentially have to make sure that you always look at each individual case, as I said, with context and regarding the severity of that case. And if you have an individual, for instance, that is on parole for a serious felony, you don't just take any type of plea bargain to get a number. Justice is not about any type of number for a conviction rate. Justice is about treating individual cases, as I said, individually looking at each regarding what context they were committed in and what type of crime and what kind of person that you're dealing with. If you, like I said, just treat someone like a number and give them any type of conviction, let's say they committed a murder, but you think it's cheaper and easier just to take a plea to a voluntary manslaughter, that's not justice and that's not making the public safe. If you have, for instance, like we have, I think there were 29 felons that were that were arrested between January 1st and the end of August, felons that were on parole that had firearms, but only 6 of those cases were ever prosecuted by the district attorney's office. That doesn't make us safer. Those are types of examples as to when you do the job correctly and you make sure that those who are committing the most violent offenses, the most serious offenses, aren't just simply back out in the street before a police report is even dry. That's how you make a community safer. And we have rates in this county that, and numbers in this county that are very, very troubling. If you go to the Department of Justice and you look on their statistics from 2003 to 2009, you'll see that they started in 2003 at 394. I believe that in 2009, they went up to 541. There, I believe, are many reasons for this, but I think a significant responsibility is that too many of these violent offenders are out on the street again and again just merely because decisions are made based on economics of getting a number as opposed to really weighing the individual cases to make sure that justice is done.
Thank you, Ms. Jackson. Mr. Reid.
Ladies and gentlemen, I want to assure you that our absolute unequivocal commitment to this community is to make this community safer. Ms. Jackson's comments or insinuations to the contrary are completely false. And it's a complete disservice to this community and individuals in this community. Having said that, most people are law-abiding. There are some people that are not. Not all of those people that are not law-abiding are violent. The first thing we need to do to make our community safer is to work to take violent people out of our communities, and we strive to do that. And the results are clear. Ms. Jackson talks about statistics. Go to the California Attorney General's website and look at the statistics. You will see since I've been district attorney, Humboldt County has become safer. There has been an increase of crime in 2009. But there are not 2 points to make a trend. You look at the numbers speak for themselves. What we work to do is be efficient, effective, take violent people out of this community for as long as we can under the law. Do effective outreach to this community, go to our schools, work to educate, form partnerships with all members of the community, from governmental and non-governmental organizations, to work under all circumstances to promote justice for everyone and respect for the law. But without a doubt, you need to have a broad spectrum approach to crime in this community. It is a crime to drive without a license. It is also a crime to leave your car, abandon your car. That's crime that does not belong in prison. There are violent crimes where those people need to go to prison, and we work hard to send them to prison. And they do go to prison if there is sufficient evidence to send them to prison. What we need to do is address one of the key causes of crime in this community, and that's addiction, both to alcohol and to drugs. And that is, people need to understand that our #1 drug problem in this community is alcohol. The second #1 drug problem in this community is prescription drugs. So we have significant issues with that, and we simply do not have adequate sources to treat these people. The jail is not, neither is prison, an appropriate way to deal with addiction, nor is it an appropriate way to deal with mental health issues or homelessness. So we need to clearly delineate crimes of violence from crimes that reflect social issues, and work to have legitimate, effective alternatives to incarceration for those sorts of social issue type crimes. Addiction, homelessness, crimes associated with poverty, and at the same time, clearly delineate crimes of violence and work to take those people out of the community. And we, the people in my office, are absolutely dedicated to this community. I am proud of them and their dedication to making this community safer, and they are working every day to do so.
Thank you, Mr. Gallegos. Ms. Jackson?
Yes, well, Mr. Gallegos and I will have to disagree on this one. I'm going to agree with the Department of Justice. I've got their statistics here in their crime stats from 2003 to 2008 and their 2009 advanced report. And as I said, in 2003, the number of violent crimes reported was 394. It went up to 428 the following year. Then it hovered about 400 for the following 2 years in 2006. In 2005, went up again to 482 in 2007, then went down just a tad to 459 in 2008. That is about approximately a 16% rise over that course of time, where in the following year it jumped drastically. The number went up 17.9% from 459 to 541. So the statistics that are on that website, and I've got them printed right here, just don't support what the district attorney is saying. However, if you also go to the same statistics, they do have a disposition. If you go to the adult felony disposition site on table 6, it shows that there was 1,785 court dispositions on the felonies that were tracked by the Department of Justice. That in 2003, that fell to 1,460 in 2008. The convictions went from 1,500 in 2003 down to 1,231 in 2008. And prison commitments for those types of crimes went from 198 in 2003 down to 153 in 2008, and that is approximately a 25% decrease. So we're just going to have to agree to disagree here.
Thank you, Ms. Jackson.
You're welcome.
Mr. Gallegos?
I invite everyone to go to the California Attorney General's website and look at that, as well as the California Department of Corrections website, which reflects the work we do. We are a public agency, and the work we do is reflected in those statistics. And I do want to remind the listeners of the early part of the campaign, the primary, when prior to the spike in 2009, when we were repeatedly letting this community know that crime has gone down, where Ms. Jackson was saying that clearly has nothing to do with the district attorney's work. And once there is a spike, of course, we are responsible for it. Look at the numbers. I don't argue with numbers. I'm an economist at my undergraduate degree. I'm an empiricist. Look at the numbers, make your own conclusion. If you agree with Ms. Jackson, fair enough. But I think when you look at the numbers, what you'll find is that she is misrepresenting the facts.
Thank you, Mr. Gallegos. Now, I'd like to get the position of each of the candidates on the prosecution of white-collar crime. As we know, in the United States in the last number of years, there have been numerous people that have been very, very badly damaged by different kinds of white-collar crime, and we'd like to ask each candidate, basically what your stance would be, and would you be willing to prosecute these sorts of cases in Humboldt County as district attorney. Mr. Gallegos?
My position on white-collar crime is, first of all, it's crime. It's against the law, and we prosecute it, either through criminal actions or through civil actions, depending on the nature of the case. White-collar crime is the largest form of crime, has a greater impact on citizens than all other crime combined, certainly financial impact, and it is wrong. It is something that law enforcement must work to do. It is an educational process that law enforcement is going through. We need to become as sophisticated as the people that are engaged in it, and that is often difficult in rural areas like Humboldt County, that level of sophistication to adequately assess what is in fact white-collar crime and not civil matters, and to put together a case and proceed on that. Our office does that. We have an attorney that is, one of the things we did was develop our Consumer and Environmental Protection Unit, and we have an attorney that has extensive training in this arena, and that is exactly what she enforces, not only environmental offenses, but white-collar crime and civil enforcement issues. To me, the skilled nursing case was in fact, although it proceeded as a civil case, is analogous to white-collar crime. You had a business that was, excuse me, not providing adequate staffing levels, and unlawfully and unnecessarily exposing elder people and dependent adults in this community to an unnecessary risk of harm. What often happens is the criminal penalty for that sort of conduct is in fact misdemeanor. And if we file a civil matter, we get a fantastically larger consequence to them. And what we try to do is make sure that the consequence of that conduct exceeds the money they saved in engaging in that conduct. We have many, many examples, but what I would end with is saying, absolutely, folks, just because someone wears a suit and a tie doesn't mean they're immune from the law. We have to, and we do, prosecute cases without fear or favor, and that is a fundamental position that I have always had, and that is that everyone gets the protections of the law, but everyone is also accountable to them. And if a business person is committing white-collar crime, or a non-business person is, they should expect to see us in the courts and expect to hear us asking that they go to prison, or there be an appropriate consequence to dissuade them from such conduct in the future.
Thank you, Mr. Gallegos.
Thank you.
Ms. Jackson?
While I have always focused priorities with respect to violent crime, I see white-collar crime as being, in many respects, as horrifying. It is my position, if elected as your next district attorney, to take white-collar crime, in fact, seriously, not to give it lip service. When you have entities or individuals that are out, that are committing these types of offenses, they are devastating sometimes the lives of just not one or two individuals, but entire families and entire communities. We have heard stories about individuals who have lost their entire life savings, that have come close to Social Security age, or elders that have been built out of everything that they own. These are horrifying crimes, and they are devastating crimes, which is why I intend to really focus back on those that are in fact crimes. I think that the diversion of focus in the district attorney's office off looking at chasing civil suits as opposed to focusing on actual crimes has done a disservice to this community. In fact, instead of, we should be looking at cases where, for instance, people have in fact been bilked out of hundreds of thousands of dollars, and I do know of cases where we've had elders who who, at least one case when I was in 2005 to 2004 when I first started practicing civilly, that there was a judgment against a conservator for several $100,000, but that case was not pursued through the district attorney's office. In fact, I spoke with the beneficiary who told me that she had a meeting with Mr. Gallegos, and he said that they didn't do those types of suits. I want to know why not. Because that type of embezzlement of that type of money of that elder is to me a white-collar crime and needs to be addressed. So I can assure you, if elected as your next district attorney, I'll give you more than just lip service when it comes to discussing white-collar crime. I'll actually give you action.
Thank you, Ms. Jackson. Mr. Gordon, 2-minute response, please.
Embezzlement is a crime. If we have evidence of embezzlement, we're going to prosecute someone, no ifs, ands, or buts. Yeah, there's just no ifs, ands, and buts about that. We do that on a regular basis. That's what we do. My record stands for itself, ladies and gentlemen. This community is well aware of the work we've done regarding elder, people that abuse our elderly, and white-collar crime. I think not only am I well known in this community for doing that, but throughout the state. And many of our cases have received national attention. So there is no lip service. I believe in hard work, not tough talk. And you know, I think this community, and I think you, the listeners, are very much aware of that. You know the facts, and that's the way it is.
Thank you, Mr. Gallegos. Ms. Jackson?
No rebuttal.
As we all know, there are a lot of folks here in Humboldt County who are very poor.
Yes.
If anyone ever saw the OJ trial, and I suspect everyone in this room did, and probably a lot of the folks watching, it was pretty apparent that the defense that Mr. Simpson got was not anything like he would have gotten with the public defender, including, I mean, having very extremely talented attorneys, bringing in nationally known forensic experts, things like that. And so the question I have for you folks is this: are there two levels of criminal justice in the state of California? One for the rich and one for everyone else. And we'll ask Ms. Jackson first.
Well, Greg, I would have to tell you that sometimes there are, and when I say sometimes, I want to make sure that I really qualify this. I've known some of the most committed defense attorneys and really incredible individuals that work very, very hard to defend their clients. They go to the mat, they work all hours of the day or night. They have merely to make sure that the rights of their clients are completely protected and that the state prove beyond a reasonable doubt that which is charged against an individual defendant. With that being said, they don't have, it's impossible to ever have all the same resources as an individual who's very wealthy, who could perhaps hire 5, 6, 7, 10 attorneys on all the investigators on the planet in order to prepare a case and to poke holes in a prosecutor's case. So while I say, yes, there are two levels, they really have to do more with the resources, but not with the dedication of the attorneys, because I do believe that the vast majority of defense attorneys would go to the mat and do everything possible for their clients. They just, as I said, don't have that unbelievable bank of resources or endless bank account that some individuals do.
Thank you, Ms. Jackson. Mr. Gallegos?
I think most people think that there are more than two systems of justice. It's not just rich and poor. It's based on race. It's also based on status in the community. It's based on the uniform you wear, or the tie that you wear. And we certainly strive every day to make sure that this community understands that we do not operate under fear or favor, that everyone gets equal treatment, and that we are absolutely dedicated to everyone receiving the protections of our laws, but also everyone being held accountable. Here in Humboldt County, an issue that we have dealt with for years is the disproportionate population of Native American youths in the juvenile hall. recently the probation department received a grant. The probation department and many departments, including mine, are working to find out what causes this disproportionate population. And do we have similar disproportionate populations in our adult incarceration levels? We need to continually reflect upon the work we're doing and look at the data that comes out of it. We need to have a justice system that operates without reflection on the economic wealth of the defendant. And I think clearly this community knows that I have done that. We need to have a district attorney's office and a legal system that also reflects, that works hard to level the playing field. I think this community knows that I have worked to do that. We need to have a district attorney that works to promote justice for all people, regardless of their race. That's why we have reached out so diligently and so emphatically the Native American communities, the Hispanic communities. We need to let them know that they are members of this community, that they are entitled to all the protections of this community, and we will always be there for them. But is there injustice? Yes. And as Ms. Jackson said, it is not due to the dedication of the defense attorneys or the prosecutors. It is, these are social issues that were a long time getting here, and they're a long time in getting resolved. But it's everyone's individual commitment to addressing these issues that work towards alleviating these social ills, and we are absolutely committed to doing that. And my record clearly stands for that across the board.
Thank you, Mr. Gallegos. Ms. Jackson?
I wish I agreed with Mr. Gallegos. Perhaps I wouldn't be running, but I do disagree. The simple fact is that we do have a socioeconomic aspect of our criminal justice system that has an impact on it. We do have a higher proportion of juveniles in, for instance, our juvenile justice system here in Humboldt County that are Native Americans, but we also have a very high proportion of Native Americans that are incarcerated in our jail facilities. I believe a lot of that, as I said, has to do with socioeconomics, in that you have, if you have individuals that are far displaced outside of the hub of the city, then they find it much more difficult, for instance, to comply with certain terms of probation or to go into and excel in different programs. They sometimes have an inability to even get in to see their probation officers, which increases their potential for having probation violations or parole violations. So back to your initial question, are there two levels of justice when it gets down to it, and do they, for instance, involve economics? Yes, they do. And it is a simple but a sad part of our reality, is one that we do have to be mindful for and try to address. But I don't think it needs a $100,000 grant or study. We do know what factors are enter into this disparity, and we can address them.
Thank you, Ms. Jackson. Mr. Gallegos?
You know, the data is out there. People of color have a greater likelihood of having police contact than people, white people. So, you know, there are big issues that this community, Humboldt County, has to face, that the state of California has to face, and the nation has to face. These are longstanding issues. We are getting better. The first part is awareness of it, acknowledgement of it, and training, and education. And the grants enable people to look at the data so that we can assess whether this is institutional or whether it's race-based, or what sort of factors are leading to this disparity. And we need to do it under all circumstances, with adult populations, with juvenile populations, when it comes to the death penalty, when it comes to you know, incarceration rates and arrest rates. So you know, we have a lot of work to do, and you know, unfortunately, that work requires time and commitment and resources, and you need money to do that. So certainly we will continue to search out and reach out for grants that enable us to put resources to study these issues, so that we don't just operate in the dark, and we work to come up with solutions based on fact instead of hyperbole and fear, prejudice, or preconceived ideas that aren't supported by evidence. So we're going to continue to do that, and it is a problem.
Thank you, Mr. Gallegos. And by the way, a point of clarification, I did not prepare these questions, and so I do not suggest that the public defenders in this or any other county are not extremely competent and extremely dedicated. I just have to get on the record as an ex-PD. I can't let it go.
Okay.
They are extremely competent and extremely dedicated. I know them all.
Okay, now, an interesting question that came in from one of our viewers. Can we build or rebuild trust between young people and the law enforcement community, which includes the district attorney's office? And I guess Mr. Gallegos?
I certainly trust young people. I don't know where they're, excuse me. You know, yes, of course we can. And we strive to do that. You know, one of the things we do is work hard to outreach into our schools on a regular basis. You know, I've participated on a regular basis on Challenge Day. You know, we go to schools, we work out, I go to the universities, we work to communicate with youth at all levels, because that's why this system is in place. It's for them. You know, I have 3 children, and I am absolutely committed to not only making this a safe place for them, maintain the quality of life that we have here for them, but also fostering in them respect for their system of government, respect for their community, and a commitment to working, to giving back to their community. And you know, my experience is this new generation, this younger generation, they are extremely talented. They are they have so much to offer, and they are going to do great things. You hear people say they don't have a work ethic. Well, I beg to differ. I see it on a regular basis. They have more information readily available to them. They have less adult investment of time. We have to spend more time with our kids. We have to promote alternatives to criminal behavior. The law needs to not be hypocritical, though. And one of the things that we have is, alcohol. Alcohol is a drug. Kids know alcohol is a drug, and it's completely legal. It is regulated, of course, appropriately so, and access to alcohol is precluded or prohibited. Cigarettes, drug. Nicotine is a drug, legal. Very dangerous, big social consequences for both these drugs, and yet they're lawful and they're regulated because adults get to use them. Marijuana, a drug that they see as not having the social consequences, is illegal and is readily available to them. It's readily available to adults. You know, they see that our governor has smoked it. You know, adults they know have smoked it, and that creates a feeling of hypocrisy, and it undermines the authority of our legal system. And we clearly, in my opinion, need to revisit that issue. We need to work every day to make sure that minors, our youth, understands that the legal system represents them. And our whole legal system and our political system represents them, and we need their involvement, and their involvement is what's going to make it great. So we're committed to reducing their distrust, and I think there certainly is a lot of work to do. But at the end of the day, it's by going into the schools and talking to them and sharing that dialogue that we can reduce that distrust. And I'd like to think that we have been able to do that. You know, I would also let the community know that the schools work with us, and we work with the schools on a regular basis. There's what's known as MAGIC, the Multi-Agency Juvenile Justice Committee, SLENS, School Law Enforcement Network, Student Attendance Review Boards. There are a multitude of governmental and non-governmental organizations and groups out there that work to exchange information and work on solutions to some of the issues that kids face, from violence, bullying, issues associated now, brought to light of bullying of gay people. Certainly we're committed to bringing trust, but also the school systems and governmental organizations across the board, Department of Public Health, are committed to promoting communications and reducing any distrust that they have and inviting participation.
Thank you, Mr. Gallegos. Ms. Jackson.
Just as a point of clarification, Greg, how long are these answers?
5 minutes.
5 minutes, okay. Can we, your question was, can we either build or rebuild trust between youth and law enforcement? Well, first of all, I would say that trust is either built or rebuilt the same way between all different groups. For instance, trust is either built or rebuilt between our youth and our teachers, much in the same way as between our youth and our law enforcement, or our youth, any type of group. It requires that there be an understanding of each one's role, that there be mutual respect, and that those groups listen to each other. If you have those three elements, then no matter what occurs, you will either be building a relationship between youth and whether it's law enforcement or any other group, or you will be rebuilding it in those cases where it's been broken. And I hate to hear of cases where it has been broken. Of course, there are some limited ones. However, I have seen work throughout the course of my career where things have actually really worked well. For instance, the old, many years ago, there was a program started that was called DARE, which is to teach children about drug abuse. And you had law enforcement that would go out to the schools and would educate children. And at the same point that they were starting to communicate together, then you had that mutual respect then and that communication and that listening, so that the person from the sheriff's office wasn't just simply a scary person in khaki-colored clothes, or a person from whether Arcata or Eureka Police Department wasn't just a scary person in blue clothes, but a real person that took part in a child's life in order to teach that child. There are other aspects, for instance, that bring children more into the criminal justice system, so they have an understanding and a respect for law enforcement. One of those is teen court, where teens actually get involved with the judge and putting on individual cases. All things like that can either build respect or trust between our youth and law enforcement, or it can rebuild them.
Thank you, Ms. Jackson. Mr. Gallegos, would you care to respond?
Oh, I agree with the teen court. We absolutely support that and participate in it. I don't even think the federal government thinks that DARE was a successful program, but fair enough. Everyone's entitled to their opinion. I think that you need to approach juveniles honestly, rationally, and we certainly work to do that, and on every arena. And I see you're getting something. I'm not sure if it's pertinent to this, but I would end at that.
We're running on time, and so we're going to ask one last question, and we're going to limit the responses to 2 minutes on this one because we need to kind of fit things in. And this is kind of a hypothetical case. You're doing a trial, and somehow you find out that a jury member knows either one of the parties, one of the witnesses. What would you do? And so I guess our first question is Mr. Gallegos.
You have to immediately notify the court. The court will excuse all the other jurors that breaks the trial, excuse all the other jurors, and there would automatically be a question and answer process with that particular juror to see whether that juror should remain as a juror. If the court feels or has adequate assurances that that juror can fulfill their responsibility of being a fair and impartial juror, then the juror may be able to stay. If not, the juror would be asked to leave. When you select a jury panel, you always select alternate jurors so that in the event someone is sick or finds out they cannot be fair and impartial, that they are excused. So those are processes that are in place to make sure that if such information becomes available, you can readily address that and resolve it so that the defendant, who is entitled to a fair and impartial jury trial, 12 individual jury verdicts is able to get that jury trial.
Thank you, Mr. Gallegos. Ms. Jackson.
Well, of course, if you're doing a jury trial and you find out that you have a witness that, a juror that knows either a party or a witness, you are absolutely duty-bound to immediately notify a judge. Then the process is essentially the defendant's attorney comes in and the judge then questions that juror regarding exactly what that relationship is. It is not, for instance, uncommon to have, it is uncommon for a juror not to tell you that he or she knows a party. What is not uncommon is for a juror to find out down the pike, so to speak, that they are familiar with a witness. Because sometimes, for instance, people don't recognize people's names, but they do recall faces when they're in. So there's usually you immediately notify the judge, and then the judge does that determination as to whether or not this is something that is intentional or it's unintentional. Because if it's an intentional deception, of course, you couldn't have someone remain on a jury. But if it's unintentional, whether or not it's significant or not. So that is, in essence, what would happen.
Okay, maybe we can now move to our closing statements. They're limited to 2 minutes long. Mr. Gallegos.
Thank you. Ladies and gentlemen, thank you for listening. I want to also thank the ACLU and once again my wife and kids. Ladies and gentlemen, I have been your district attorney for the past 8 years. During that time, we have worked to change what was a moribund district attorney's office into a modern, efficient, and effective district attorney's office. We have worked to attract the best and most effective attorneys, our investigators, the best and brightest investigators, and an outstanding victim witness advocates and clerical staff. As a result of that work, we have been able to solve cold cases, bring cases to justice, expand the work we do from the usual pre-existing paradigm of focus only on criminal cases without reflection on the needs of the community, excuse me, and prioritizing violent offenses into an office that prioritizes crimes of violence, crimes against vulnerable members of our community. Despite repeated budget cuts, we have established the Criminal Investigations Bureau, which this community hears about on a regular basis from the cases we